Hello viewers, welcome to my channel Legal Decipher. If you are new here, then you can check out the other videos on CRPC and IPC from the channel playlists. This video will be a short introduction to the Indian Evidence Act of 1872. So let's get started. The Evidence Act consists of 3 parts in which there are 11 chapters and 167 sections when it was first enacted. However, later some more sections were added due to various amendments. Some original sections were even repealed later. This act was enacted in the year 1872. The Indian Evidence Act is one of the important statutes of our legal system which deals with the rules of evidence and is applicable on both civil and criminal cases. The purpose of this act was clear and simple: to define and amend the law of evidence. It is a procedural law with an object to restrict the investigations made by courts because otherwise it would make a lengthy trial resulting in failure of justice. Now, if we search history and trace back the origins of the evidence in India, we will realize that the concept was already there and it was well founded in our culture. It only got developed over time, mostly during the kings of the Hindu period and then the Muslim period. During the Hindu period, the rules of Hindu Dharmasastra was enacted, which recognized 4 types of evidence. Firstly, there was the concept of lekha, which literally meant documents. Lekha was further subdivided into 3 types, namely Rajya Sakshayak, that was like a registered document made by the clerk of the king's court. Then Sakshayak, which was a written document by a private person attested by witnesses. And then there was Asakshayak, which was a written document by parties themselves without any witnesses. Also, there was the concept of Sakshi, that was oral evidence which had less value than lekha. Then there was bhukti or bhog, which resembles the concept of possession or use, which was well settled in ancient India. It was of 2 types, sagma and anagma, which denoted possession with right and possession by origin. However, it was developed to such extent that the king would punish the man as a thief if he failed to establish his possession, and for that purpose it did not matter for how long he had been in such possession. It was also established that if a person delayed in his claim of justice and rightful ownership, despite of seeing that another person is in wrongful possession of his property, then he would get back his property but not the profits lost during such wrongful possession. So a lot of such sound concepts were there. Also, there was Divya or divine test or ordeals, but it was not that important and was used only in those cases where there was no such human evidence available. It also got lost in time over the developmental process of the evidence system. So as we can see, the Hindu system of evidence had advanced much in course of time and many modern concepts were taken directly from that era. Then came the Muslim period and the kings of that time adopted the Hindu system and developed it further. For example, the concept of oral and documentary evidence along with all other concepts that we just learned were adopted, but they were further developed. While oral evidence got divided into 2 subcategories, direct and hearsay, this is where the concept of hearsay evidence originated, and it was less preferred as to direct evidences like we see today in our legal system. Also, the demeanor of the parties and witnesses to a suit were scrutinized. Examination of a witness along with cross-examination was advanced, conducted in separate for each of such witnesses. Also, near relatives, partners, persons of unsound mind, blind persons, drunk persons and minors were not qualified to testify. Then there was circumstantial evidence, which was also given value, like if a person was seen in fear and anxiety with a blood-stained weapon in his hand coming out of a deserted house and subsequently a dead body is found in that same house, it would be concluded that such man had committed the crime. So as we can see, most of the concepts of the ancient Indian culture relating to evidence was sound and developed, but the only problem was that they were rather well established practices and not a set of codified rules. In the modern times, those theories and concepts were built on upon exhaustively and they were inducted into the statute in an organized and codified format, which is known today as the Indian Evidence Act. The statute has 3 basic parts which deals with the relevancy of facts, proof of facts and production and effect of evidence respectively. We will start going through the statute from the next videos. So that's all in this video. If you like my videos, then don't forget to smash the like button and subscribe to my channel. Thank you so much for watching this video.